See. And here in just a second, I'll open up. Oh, we've got 51 now.
Yeah.
52. All right, I'm going to let everyone in.
Great.
Welcome, welcome, welcome everyone to Tuesdays and Thursdays with CarePatrol. We appreciate you taking time today to share with us and to invest in yourself and in your knowledge. Today is Tuesday, April the 12th, and I had scheduled erroneously Bill Nolan to do two presentations and mixed the dates up with him. So today we're pleased to have Bill and Pam Strickland, who was to be with us on the 21st in my brain, but in no one else's but mine. So I'm winging it, and I hope y'all will do so as well. And we're also going to present a new forum here of ways to do these presentations. This is going to be much more of a discussion mode. We're not going to offer a PowerPoint or slides. Instead, we're going to have a real discussion between Bill, who's an elder care attorney of some years now, one of the first in the Birmingham area and one of the first to be credentialed by the VA for the aid and attendance pension accreditation, and Pam Strickland, who has worked both with Bill in his office as a paralegal and on her own now for the past 18 years as someone who helps with the Medicaid application process with others. So it's good news and better news. We've got Bill and we also have Pam. So great. I hope we can adapt to this. And as you know, there's some housekeeping with what we do, and I'll run through that without the slide. It is that, as you know, we are accredited by the Alabama Board of Social Work and also by the Alabama Board of Nursing to provide contact hours for both nursing and social work. And in order for us to meet the burden of providing you with 55 minutes of content that is educational and enriching to you, we have to show that you were here. So there's two ways we do that. One is we have what we call a password or a code word, and I'll be both saying that aloud for those of you on the phone and also putting it in the chat room for those of you who are visiting in by Zoom and by computer. So we'll be mentioning the code word later in the presentation, and we do it later so we know that you were listening and that you were here. And we then also, at the end of the presentation, have to have you do an evaluation. This shows us that you were here, that you paid attention, and whether or not this was helpful for you. And we really want you to give us honest, positive, well, not positive, we want you to give us honest feedback. We hope it's positive, but if it's not, don't fear, we can take it. We're adults. So please let us know how you feel about what we have to say to you all today. Again, we appreciate you being in. And for those of you who've come in late, I have made a miscommunication error, and I have overbooked Bill and Pam and really sort of mixed up dates. So Bill and Pam today will be presenting for us Medicaid misconceptions. We will not be listening to Elder Law 101. Instead, we'll do that on the 21st with Bill. I don't know if Pam may join him or not, but today we have Pam and Bill doing Medicaid misconceptions. I hope you all who have an interest in Medicaid will find this enriching. And those of you who were looking for an elder law CEU and more than that, the education around it, come back on the 21st. So I want to get everyone in now that I can. I believe we're all in. I've explained our process of evaluations, which you all know very well. I've explained our code word. I'll give that to you later. We have a survey on SurveyMonkey. I'll read out the address for you later in the presentation or at the end of the presentation as well. And as for now, I will have Bill and Pam just take over. And welcome and thank you for joining us at Tuesdays and Thursdays with CarePatrol.
Great. Thank you, Sean. Looking through the list of people, I see quite a few names of people I've worked with in the past. So thanks for joining us. Today, we're going to talk about one aspect of elder law, which is Medicaid. Now, there's other aspects to the practice of elder law besides Medicaid, but it makes up such a huge portion of what we do and the area of specialization that we offer. It warrants its own separate webinar. Think of this as a podcast, by the way, since we don't have a PowerPoint to show you. This is a podcast. We'll pretend it's a podcast. So you're just listening to two people talk. And what I thought I would do is Pam and I would go back and forth on some of the more common misconceptions we see over and over and over. And I'm sure you've heard these misconceptions in your practices and in the work you do as well. So we want you to be able to walk away today and never have to say, I wish somebody had told me that before now, because we hear that so often. Medicaid is not one of those agencies that will forgive mistakes. Is there anybody here who works for Medicaid? Any of the attendees? Any way you can signal if you do? We don't want
Yeah, if y'all work for Medicaid, just go to the chat room and let us know.
Jerry says she is. Okay. Well, we're not here to offend anybody. We just want to lay out our understanding from what we do from the patient's or the applicant's side. And of course, I'm sure there's other opinions out there as well. Pam, I guess the first misconception we see over and over and over is people are concerned that they're going to lose everything when they apply for Medicaid. So would you go into some, truth to that?
Absolutely. We hear a lot that people say that I'm putting my spouse in a nursing home. I'm going to apply for Medicaid. Therefore, I won't have anything to live on. And that's a huge misconception. Medicaid has something called MIMNA, which is the minimum monthly maintenance needs allowance. And when you have a spouse, the one who stays home is called the community spouse. And Medicaid does not allow them to fall below a certain income threshold. So for now, and it changes each July, but for 2022, that threshold is $2,178 per month. So if the spouse, let's say the husband is going into the nursing home and the spouse, the wife, only makes $900 a month in Social Security, Medicaid will run it through their process and give her a portion of his income to meet that threshold of $2,178. Also, if a married couple and they own a home, that home gets to stay with the spouse. So they don't lose that home. The spouse continues to live in that home. And they also get to keep a car. That's off the table. So they don't lose those things. They get to keep those things. That misconception comes in because rumors like I lost everything when I went into Medicaid, or my uncle wanted Medicaid. It all depends on the case and if they're single or if they're married.
Right. Are you? Is this a good time to talk about the Community Spouse Resource Allowance as well?
Absolutely.
So tell us a little bit about the Community Spouse Resource Allowance and what that means and how that works in a couple arrangement.
Absolutely. In a couple arrangement, the couple has assets. And for this year, those assets can go up to $260,760. And one half of those assets belong to the spouse, and the other half belongs to the individual that's going into the nursing home. So you split that down the middle. The person who is going into the nursing home must spend down that amount to below $2,000, or they can, there's different ways we can treat that. There's something in Alabama called the Alabama Family Trust, and that portion can go into that trust to get them qualified for Medicaid financially on the first day of the next month after that trust is filed. And the community spouse gets to keep $130,000, $380,000 for theirs. So they're left with that. Now, if it's less than that, let's say that the couple has $80,000. They would still split that 40 and 40. Let's say they have $27,000 between them both. They're living paycheck to paycheck like everybody else. There is no spend down. They get to keep all of that. The community spouse gets to keep all of that. They would be, the spouse going to the nursing home at that point would be considered indigent or $2,000 or less, and would be able to be Medicaid qualified when going into the nursing home if they've been in there 30 days. Then we can apply for Medicaid at that point. Let's say you have more than $260,000. Well, that's where the cheese gets more binding. That's where you have to spend that money down. There are Medicaid annuities, I'm sure that Bill can speak about, that are approved Medicaid annuities that you can invest in that could hold a certain portion of that money. But all in all, Medicaid does not allow the community spouse to be broke. And I think that, I'm sorry, I was reading a question from.
Yeah, Pam, I was going to interrupt you. I'll read it to you. It's what if the home deed is in a parent's name and in a child's name, both names on deeds over 5 years?
You want to answer, Pam?
Well, if it's over 5 years, well, then the Medicaid look back is 60 months. And so the house is off the table at that point.
So
would you agree, Bill?
Yes, if it's a life estate deed and it's been in place for at least 60 months, then Medicaid will not put a lien on that property or require it to be sold. However, if it's just a typical joint right of survivorship deed where both spouses have a right in it, my concern is Medicaid would still see that as the applicant's property, at least half of it as the applicant's property. What do you think, Pam, on that? If it's just
I would think they would put a lien on the property for the amount that the claimant or the person applying for Medicaid for his portion of the property. That's my thought. So if the property
no spouse involved, no spouse involved in this.
Yeah, it was an individual and a child.
Right.
And the parent is going into the nursing home.
Okay.
So I would say that Medicaid at that point could put a lien against the home for a portion that belongs to the claimant. And so when that house sold, Medicaid would get a portion of that income to pay for what they paid for the Medicaid claimant.
One of the techniques that you can use with married couples is the institutional spouse, the spouse who needs care, can convey his or her interest back to the community spouse, the spouse who's going to stay in the community. Transfers are forbidden by Medicaid if they happen within 60 months of application, but you can transfer between spouses at any time. There's no penalty for that. So the institutional spouse can convey their interest back to the well spouse. And if the well spouse outlives the institutional spouse, then there shouldn't be a problem there. Medicaid might still put a lien on the property because, that's just the way they are.
Here's a question. What if there is an adult child that lives in the home and has been a caregiver? The mother needs to go to the nursing home. What happens with the property?
There you go. A softball to Pam. Go
yes. That happens all the time. And we have caregiver children, especially in these times, daily. And so there is a form that is filled out that Medicaid sends us that explains that situation. And the caregiver child can continue to live in that house for as long as needed. And but 90% of the time, Medicaid will place a lien against the home if it's sold to recoup the funds they paid on behalf of the institutionalized spouse. Do they come in and rip the home out from under the caregiver child? No.
That's good to know.
Yeah, well, when I say that, I want to preface it with this. There has to be a history there. and it has to be several years for the caregiver to live there with the parent. They can't move in a week and say, I'm the caregiver and this is that does not work at all. But it has to be a history and several years. The child has to live there taking care of the institutionalized individual.
I think the rules in their manual say that if it's a sibling of the applicant, they have to live within at least 1 year and be able to prove that. Change of address, change of voters, all that stuff. If it's a child, then it has to be at least 2 years. And grandchildren don't count, stepchildren don't count, and certainly strangers or friends don't count. So it's one of the few exceptions available, but it is a good one. Here's one. What happens if the home is never sold? Does the lien just remain on the home forever? Yeah. Are you referring to the dependent caregiver exception lien? If so, yeah, the lien's going to stay on the title forever. And as you're right, if it's never sold and Medicaid doesn't try to exercise that lien, try to sell it, in other words, after the death of the dependent caregiver, then the kids, grandkids, great grandkids could still continue living there.
So here's a question. Why don't and this is my question, why don't the grandchildren or the stepchildren count? I'm a stepchild, so I guess I'm literally a stepchild.
You mean, why don't they qualify as a dependent caregiver?
I guess that's her question, yeah, in the Medicaid.
The rules were created by Medicaid and Congress, and they said siblings and children. They didn't say adopted kids. They didn't say stepkids. They didn't say grandkids. And we've had several cases where the grandchild is the one providing the care, but they don't qualify. That's
wow. Well, that was the next question. What if you were the guardian for the grandchild? Would that caregiver exception stand?
I wouldn't think so.
Yeah. I haven't come across that one yet, but I would imagine no.
They're asking, someone's asking, Jerry Johns, who is asking about touching on property regarding a disabled adult child. She's saying that a lot of people don't know this. Maybe you can enlighten us.
Dependent, the rules exempt disabled children from, if a disabled child lives with the Medicaid applicant, the home is exempt from Medicaid forcing its sale or whatever while the disabled child continues to live there.
That's correct. Yeah.
So disabled kids don't have to worry about being displaced, in other words. Now, there is the issue of who's going to take care of the disabled child, but that's not Medicaid's concern. Their concern is exempting the asset itself. The home issue is a big issue, and one of the misconceptions I wanted to ask Pam about was transferring the home out of a person's name to exempt it from Medicaid's reach. But I think we've pretty well exhausted that topic, unless anybody has any other questions about it. Medicaid does treat a life estate deed differently from other deeds. And a life estate deed is a type of deed where the owner conveys away all of their interest in the home, except for the right to live there the rest of their life. It may be 20 years, but it's the rest of their life. If that deed is recorded or signed, technically, recorded just for safety, for 5 years before the applicant applies for Medicaid, then the home is off the table for Medicaid. Medicaid's not going to put a lien on it, I wouldn't think, because when the person dies, they don't have any interest that passes. They've already given away that interest. So life estate deeds are a very inexpensive but effective option for people to use. They have to put them in place, though, 5 years in advance. So you have to think way down the road with this type of planning.
I have another question here. Does the child's caregiver's name, child/caregiver's name, have to be on the deed for them to continue to live in the home?
Ooh, that's a tough one. Because sometimes the disabled child might be receiving benefits, Social Security disability benefits, Medicaid benefits, and having an asset in their name might cause a problem with them continuing to qualify for those benefits. On the other hand, when a dependent caregiver, a regular dependent caregiver, is, and I haven't done this in a couple of years, but I remember a couple of years ago, Medicaid just said deed the home to the caregiver. We recorded a deed from the applicant, Medicaid applicant, to the caregiver, and it was in his name for, forever, no lien or anything. But lately I've heard Medicaid has tightened up on that, and they're putting a lien on the property while the caregiver lives in it. Does that mean, Pam, in your experience, are they conveying the home from the owner to the caregiver, or are they just leaving the home in the applicant's name while the caregiver lives there?
I would imagine that Medicaid would see that as a transfer of asset. And I'm not sure if they would say that there should be some payment for that.
Mm-hmm.
It would seem to me that if there's recorded evidence of the caregiver being there with a disabled child, that would be a situation where that could happen. But that's a very difficult line. That would have to be, we would have to talk with the supervisor, explain that, give her the evidence, and let a supervisor. She would then talk with the legal department, and they would make that decision.
I'm not a big fan of relying on the dependent caregiver exception.
Yeah.
The rules say that you have to live with the person for 2 years, the 2-year period immediately preceding the Medicaid application. And in many cases, what happens is a person will live in the home and then go to assisted living for a period of time. Mm-hmm. And the question is, did that 3 months in assisted living break that 2-year period? In my attitude, it did. You're no longer the caregiver for the last 3 months because they've been in a assisted living. But those are all speculations. What we found with Medicaid is they will take a position and we will argue it. And if we can't be persuasive, then we'll go to a fair hearing. And the fair hearing is held with a couple of Medicaid employees, and generally they don't work well in favor of the applicant. So then it goes to the Court of Civil Appeals, which is just a regular court. And the case is heard there, and rarely does it come back in favor of the applicant.
Yeah.
So yeah, you can take a position that's counter to Medicaid, or you can even take a position that technically is within the regs. But if Medicaid says they're not going to accept that position, the chances are slim to none that you're going to be successful. I hate to say that, but that's been my experience.
Yeah. I would agree with that, Bill. I've seen it go. I've seen evidence, and I've seen it presented, and I've seen them absolutely hang tight with their decision and not change, even though we had the evidence that was needed. And it's heartbreaking for the family, but it does happen. So that's a road that is rarely traveled and successfully fought.
One of the questions I meant to ask you earlier, Pam, and it has to do with the community spouse resource allowance.
Yeah.
Which is Medicaid's way of saying the spouse who stays in the community does not have to be destitute before the institutional spouse is eligible. And that's where they say you get to keep 50% of everything up to a certain amount. Mm-hmm. What I've seen is where within a married couple, one spouse goes into a nursing home and the community spouse continues to pay for that person's care privately until they're completely out of money. And then they come to us for a Medicaid application. Yeah. And my approach is, I wish you'd come to see us sooner, because you could have kept half of everything up to that certain amount. Mm-hmm. That your understanding as well how that CSRA works?
Absolutely. I think that the problem out there today is that there's lack of what we call long-term planning. And people of a certain age need to start that immediately, because it gives you a 5-year window where your health is good. And then let's say something happens 7 years down the road where your assets during that 5-year planning, like with an attorney like Bill, would be placed in certain trusts and things, so that it can be retained, and Medicaid cannot dip into that. So what I see is, unfortunately, families coming to me when it's too late. The parents have been in a nursing home. They've spent all their money. The spouse really has nothing to live on besides just Social Security. And if they had come earlier, we could have saved them 50% of what they had. And if they had planned 61 months ago, well, then most of that would be available for the spouse. So it's all in the planning, and it's knowing, and I know it's hard to get a parent. In these days, the child becomes the parent, and they have to force their parents to do things. You need to get a will, you need to start this planning. But for the long road, it's the best thing that you can do. The parents can do to get the stress off the children and to save their money and be able to take care of themselves down the road when they have nothing else. Retaining that that money and retaining their freedom in that is very important. And unfortunately, these days, very few people really know about it and work with that. So when they come to us, they're excited to know they can keep at least 50% of what they have. And we work very hard to make sure that they're well taken care of.
I just wish that people would come to see us long before they've spent down their money, because 50% of 50,000 is a lot less to keep than 50% of 270,000.
That's right.
And they don't know any better. Nobody ever told them. So please, when you have family members or patients or clients who are thinking about Medicaid, please encourage them to explore their options, because the community spouse, their life can be so much more comfortable with
$130,000
than it would if they had spent every dime they had. So please be thinking about that.
Here's a question. Why does Medicaid want burial policies to be, cashed in to pay for care in a nursing home? What's that about?
Yeah, Pam, if you would go into a little bit of detail about your experience with the whole burial.
Absolutely. First of all, there are two specific misconceptions about Medicaid. First of all, one of them is about the burial part of Medicaid. One is that we can only bury, we're going to have no money to bury our parent, and they have these policies. But what needs to be done is a pre-need burial set up. That means that the family would go to the funeral home, and they would set up two things. They would set up the funeral side, and they would set up the cemetery side. Now, these policies can be used and pledged toward the funeral, and it's written in a contract, and that contract should be irrevocable, and it's got a little block at the bottom that you would sign. And the funeral side of this, and we're talking the funeral director side, the embalming, that takes place for the funeral cannot be above $5,000. That does not include anything in the cemetery. They don't look at anything at the cemetery. Mausoleums, crypts, caskets, opening, closing, headstone, foot markers, all of that is not included, which means they don't care what you spend on that. It's just the funeral side. And so these policies that you have should be pledged toward the funeral and should be written up in the contract. And the funeral home at that point would say less $500 for the vault policy, less $300 for the casket policy. And they would go through and list that to give you that discount. And at the bottom, you would sign the irrevocable thing, which means you can't change it, you can't take it back, and you can't cash it in. If you do it that way, that's fine. That's acceptable. But if you have all these policies laying there and you don't have it pledged anywhere, that's an asset. You can cash that in and get money from that. And that's an open asset. And that's why at that point they would do that. So I always tell people when they come to me, go ahead and get the pre-need set up. Go ahead and pledge your insurance to the funeral. If you have a $10,000 policy, you want to use it for the funeral, pledge it to the funeral. That means take it with you to the funeral home, have them put it in the contract, X amount, policy number, and it's listed on there. And it's at that point off the table, and Medicaid will give a burial designation form to the individual to complete, which means these funds are designated toward the funeral, so therefore they're not considered an asset. Is that explanation enough? You need more?
I will say that the burial portion of a Medicaid application is probably the one that's most confusing to me.
It is.
The rest is good, but I just basically turn that part over to Pam and say, you figure this out. My skill level. So I don't blame you, whoever posted that question, for asking that question, because it's a good question.
It is.
The subject of the Alabama Family Trust, I want to touch on that because it's such a great tool here in Alabama. Let's say that you have a single applicant, and the single applicant has $50,000 in their savings account, and they are now in skilled care and would otherwise be eligible for Medicaid, except they're over-resourced. Many families would just take the attitude, well, we need to spend that $50,000 down in $8,000 monthly increments until we're below $2,000, and then we can apply. But there's another option, the Alabama Family Trust. So talk about that a little bit, if you would.
Absolutely. We use the Alabama Family Trust tool monthly. Bill and I both do. And we would take the funds that are over $2,000. I usually like to get someone down to about $1,500 because you've got income coming in. But we take that money and we would open an Alabama Family Trust. Now, this means that we would fill the documents out, and the family would get us certified funds from the bank. We would give that to the Alabama Family Trust. Now, this trust is set up so that the family or the sponsor or the power of attorney or the conservator, whoever is appointed over this individual, can spend that money on behalf of that individual in the nursing home from the Alabama Family Trust. That means they can have a private room, and they can send a receipt for that private room to the nursing home. To the Alabama Family Trust monthly. Alabama Family Trust would pay that differential. Alabama Family Trust funds can be used to pay for their phone bill, their cable bill. If they need a reclining chair to help them set up, you can buy that through funds of the Alabama Family Trust. You can purchase, if this person needs to be taken to therapy or doctors or whatever, and there is a van needed, you could use these funds through the Alabama Family Trust to purchase that van up to the amount that you put in there. And there is an approved list of items that you get from Alabama Family Trust. So the trust holds the funds and they invest those funds. And then you come in with receipts and you ask for reimbursement, or you ask for direct payment through the Alabama Family Trust. And if it's on the approved list, they will certainly write that check and pay that on the behalf of the claimant who's in the nursing home. Now, let's say that claimant passes away and there's $25,000 left in the Alabama Family Trust, and Medicaid spent $32,000 on their care. Well, at the point of death, the trust is frozen, which means no other expenses can be paid from that account. And an affidavit is sent by the Alabama Family Trust to Medicaid in Montgomery, and they say, how much did you spend on Mr. Smith's behalf? And Medicaid fills out an affidavit and sends it back to the Alabama Family Trust. Well, the money in that trust, first and foremost, goes to pay Medicaid back for whatever they spent on behalf of the individual, which means if they paid $32,000 and you've got $25,000 in there, the person who is marked as the remainderment or the beneficiary is not going to get anything back. It's all going to go to pay Medicaid back, and the account is then closed. But let's say you've got $60,000 in there and Medicaid only paid $28,000. They'd pay the $28,000 back to Medicaid. Alabama Family Trust has fees, which they will take out, and then the remainder goes back to whomever is listed on the documentation as the beneficiary, or they call it the remainderment. That money comes to them, and then the trust is closed out. So that's how we use the Alabama Family Trust. It gets, and one thing I didn't mention was the applicant becomes Medicaid pending or Medicaid qualified the first day of the next month after the trust is set up. So if you set the Alabama Trust set up on the 15th of April, May 1st, they're Medicaid pending or they have qualified for Medicaid at that point because they're no longer over-resourced.
We try to set those trusts up the week before the Medicaid application is going in, so we know exactly how much is needing to be removed from the applicant's bank account. But it's not something that you would do several months in advance. In other words, it's do immediately prior to the Medicaid application being submitted.
That we like to do the week before.
There was a question, really, I think you've answered. It was how long does the process take to be approved for the Alabama Family Trust? Asking as I have a patient who is over the monthly Medicaid limit. Thank you.
Well, it takes a week maybe.
Yeah, and it's not so much an approval as it is getting the thing that takes the longest with the trust is that we must also submit a diagnosis letter from a physician stating what their diagnosis is and why they need long-term care. And we present that with the application, and then they meet. Alabama Family Trust meets on Fridays, and normally they deposit that check the last day of the month, and that's it. It's not so much an approval as it is getting them just to get that trust deposited and that money placed in it. So usually the last day of the month it's done, and it's taken care of at that point. And the first day of the next month you're qualified.
So two other questions. One, is the Alabama Family Trust the same as the qualifying income trust? And then a second question, I'm not sure if they're related. What does it mean when a patient is told they need a qualified in trust account? I think she's asking about they're both about the QIT.
QIT, yeah. Bill, do you want to answer that one? You want me to answer that one?
Medicaid has, Alabama is what's called an income cap state, which means if your income is $1 over the income cap, you're not eligible, period. Well, in order to soften that a bit, Medicaid has allowed the creation of a type of trust called a qualified income trust, or a QIT is what some people call it. And what you're doing with a QIT is you're taking your income over the income cap and putting it into this separate, it's a glorified bank account. That's what it is. The sponsor, the spouse, the adult child, whoever it is who's helping with the Medicaid application is generally appointed as the person who can transfer money out of that. There we go, 25, 23. I have my chart here. Every 6 months we update this chart. So thanks, Jerry, for the income cap. It's 25, 23 this year. Anything over that would make you disqualified. So a QIT is something that we would set up. It takes a couple of days to set up, and there are a few banks in Birmingham and possibly across the state that still allow QITs to be set up. Not every bank does it. So you may very well have to find a bank that will allow you to do it, but it's not hard. Doesn't take a long time. It's not expensive to set up.
If I may add.
Another point, Pam, powers of attorney. I want to bring up powers of attorney because this is one of those areas where Alabama Family Trust and the QIT really create problems.
Yes.
A lot of people don't have powers of attorney at all. For whatever reason, they just didn't know they needed one. And then there are other people who have a one-page mail order, print off line thing that says power of attorney, and they think they're covered. But in order for your loved ones, your spouse, your children to be able to set up a trust with the Alabama Family Trust or a QIT, you've got to give them specific permission in a power of attorney. And most powers of attorney we see are done by estate planning attorneys. And they're not so much concerned about elder law issues. They're concerned about tax issues. So they don't include that language. Pam, what happens if a person comes to you and says, I need to set up a QIT and a family trust for my dad, and here's his one-page power of attorney, and you look at it, what happens then?
Well, first of all, I call Bill and say, Bill, you need to do a power of attorney for my client, because you have to have a specific line in the power of attorney that says, the Alabama Family Trust, that you're able to set up an inter vivos trust, and that trust is irrevocable. And that is the Alabama Family Trust. And really, you don't get those unless you deal with an elder law attorney, because they understand the concept of what this trust is. As far as banking powers, the power of attorney we used to do was 19 pages long, and 6 of those pages had to do with banking. And we're talking safety deposit boxes, deposits, setting up accounts, transfer of accounts, wire transfers. All of this is encompassed in that. Now, for a QIT, it's very important that durable, we call it the durable power of attorney, which covers everything, specifically mention that they can open new accounts, and that they can put money and withdraw money from those accounts. Now, let me touch on one thing, Bill, about the QIT. You must, to open a QIT, put dollar for dollar, penny for penny of the Social Security check to open that QIT. And then you must have the Social Security check directly deposited into the QIT monthly. That's a valid Medicaid QIT. And you just have to call Social Security and explain to them what you're doing, and then they will set up an online or phone appointment for you, because they no longer allow you to come into the office. But to make a qualified income trust or QIT a valid Medicaid QIT, you must open it with dollar for dollar, penny for penny for the Social Security that person gets per month. And you must have the Social Security directly transferred and direct deposited into that account as soon as possible. That is how you get under the income limit for Medicaid, for them to say, okay, she's Medicaid qualified as of this date, the date the QIT was set up. And that's very important to know. But you must have a valid power of attorney. And as far as the Alabama Family Trust, if that power of attorney is dated before, I think it is September 15th, 2011, they will grandfather that one in. And I think I'm pretty clear on that date, but they will grandfather that one in. But anything after that, you must have that language in the power of attorney.
Really important, because the alternative, if you don't have it, then you have to go through what's called a limited conservatorship.
Yeah.
And that costs at least $3,000 and takes about a month. And, time's money when you're dealing with
That's court.
Yeah. So if you can avoid it with a $250, $275 power of attorney, why wouldn't you?
We have another question. Have we already talked about Medicaid waiver and how the family assets are affected if the parent gets the Medicaid waiver?
I will say this, Pam may have more experience with Medicaid waiver than I do. Medicaid waiver is one of those pilot programs for here in Alabama. It's not nearly as widespread as what we're talking about, which is long-term domiciliary Medicaid. And what I found with Medicaid waiver is the income level and the asset level tends to be very low for those applicants, and they don't come to see lawyers because they can't afford to pay us. So we hardly ever see Medicaid waiver situations come through our office, but Pam, you may see that come up.
No, I've had one, and we contacted Medicaid, and they took it and ran with it because they were quite indigent, and there was just nothing for me to do. I called them, gave it to them, and that was it. So I don't deal with waivers on that part, and I usually refer them directly to Medicaid. They have their own team that deals with that.
And I have a question for y'all. So it sounds like, or I get the question is, which is the better option? I guess it depends on your circumstance, but in general, is it the QIT or the Alabama Family Trust? It's maybe easier if you lack resources.
Assets versus income. Assets, and this is a confusing area for a lot of people, but assets are bank accounts, CDs, stocks, bonds, mutual funds, real estate. Those are assets. those would be covered by the Alabama Family Trust. The real estate can't go into the family trust, but everything else could. On the other end, a QIT covers your monthly income stream. So your social
Oh,
railroad retirement, teachers retirement, all of that would be funneled into the QIT. A lot of people have both. Some people only have one or the other.
okay.
One of the reasons why the family trust is so important is because it allows a family to qualify for Medicaid so much sooner. You know, if you had, we mentioned $50,000 CD, well, if you put it in the family trust, you're eligible the first of the following month. And that's great. If you wait to spend it down in $8,000 a month increments for your nursing home bill, it's going to be what, 5, 6, 7 months before you're eligible. Another issue, and I've never clarified this with Medicaid, or I don't even know if Pam and I have talked about it, but if you are paying for nursing home care, you're paying full retail, whatever the facility charges you. Medicaid has a negotiated rate they pay for those rooms, though, which is less than what you're paying. My thinking is that Medicaid's lien will grow by what Medicaid actually has negotiated in terms of a rate. So if Medicaid's rate is $5,000 a month, your rate is $8,000 a month, your lien's going to grow on the house by $5,000 if you're eligible. Whereas if you're paying money out for nursing home care, you're paying full retail, $8,000 a month. So it makes sense to qualify for Medicaid sooner because you're really getting a bargain price. Whatever Medicaid's been able to negotiate with the nursing home. My thinking, I don't know if that's true or not.
Yes, that is. And I've talked about that many times with clients to let them know that the negotiated rate is nowhere near what they pay. Yeah. And they actually saved money in the long run by setting up the Alabama Family Trust and then paying back what Medicaid pays as opposed to what they would pay private pay.
Yeah. And you stay in charge so much longer of your loved one's care. You know, if you're in charge of their private room with the family trust, that's great because Medicaid's not going to let them have a private room. You can hire caregivers to take care of them while you go to the beach for a week, you know, and you're worried about them being all alone. You pay for that with the family trust. Otherwise, it's coming out of your own pocket. I know we're running short on time. One question that comes up a lot, and this has to do with Medicaid's requirements on the application itself. You know, Medicaid has the 5-year look back, which means they get to see everything that has happened with the applicant's finances over the last 5 years. And that's bank records. They want to see 5 years of canceled checks or images of canceled checks. Now, on my last run to the bank, we ended up paying $600 for 5 years worth of images. So it's not free. Banks aren't going to generally give you 5 years worth of checks for free. Somebody's going to have to pay for it. But what are they looking for, Pam, when they look at all those 5 years of checks?
Well, I tell my clients, if your loved one does not have online banking, set it up. And then we can print off those checks free from online banking. So that saves them a little money. But what are they looking for? Well, I'll tell you what I do. When I get those 5 years of bank statements and those checks, we go line by line by line through each and every statement, and we color code them. And we see what was spent where and how many were for cash, how many was to their son, how many was to their daughter. Was it a gift or was it a graduation gift, a Christmas gift, or was it like giving them money? We look at everything and we make a list of questions so that when Medicaid comes back to us and says, what is this about? I can pull my questions out of my file with the answers that I've gotten from the sponsor, and I can do an affidavit or a 234 form back to them to answer that. Medicaid is looking for what I'm looking for. They're looking for expenses that cannot be explained. They're looking for gifts to other people. They're looking for overabundance of cash and transfers. And I pretty much know that before I file the application, once I get those 60 months of bank statements and I look at the checks. I've had instances where we've had loans to family amounting over $60,000, and the family has come together to pay that back. If not, there would be a penalty on the individual, and they would have to private pay that nursing home until that $60,000 penalty is paid out, and then Medicaid would kick in. So that's what they're looking for. They're looking for invalid transfers, anything like that. Money coming in, deposits coming in, you better account for everything. If it was a deposit because you got a refund from your insurance, they want to know that. All of that, that's what they're looking for. Every stream of income and everything that went out.
Jerry just shared with us down here at the bottom that she works with Medicaid. She says they don't need 5 years worth of bank records.
Okay.
They have a system in place that allows them to access financial records. That's not been my experience on this one we're working on right now, but maybe that's something the Birmingham office is doing. But that would be great. You know, if Medicaid applicants no longer had to meet that requirement, it would be
That is great.
It's hundreds of dollars. Some banks are gouging people for that. And if Medicaid has access, that would be fantastic.
We have another question, which is, what does Medicaid consider an asset?
Well, Medicaid calls them resources. Resources would be anything that could be converted to cash without, probably anything that could be converted to cash, period. CDs, stocks, bonds, mutual funds, annuities that haven't been annuitized, cash value of life insurance, interest in real estate that you own, whether completely or partially.
Oil lease.
Yeah.
We've had oil leases and mineral leases.
Generally, your personal property, your television, your sofa, your Mr. Coffee,
Yeah.
your Timex, those aren't resources. Medicaid's not concerned about personal property so much. Now, I don't know about a Rolex collection, if that would, or a mink collection, if that would rise to the level, but it's any asset that can be documented. Either.
Now, if I may say, Bill, one of the questions on the application is, do you have a hobby?
Mhm.
And do you have a collection? If so, take pictures, get it, have someone come in and give us a price for what that is, and they would require you to sell it. We've had that happen.
My sister wanted to get rid of her Beanie Baby collection that way.
Yeah.
Finally, maybe get a good value for it after.
Yeah. They do ask those questions.
Well, let's see. Here's one a question just popped up. Oh, that's another one. That doesn't have to do with today's presentation. I think the thing to remember about Medicaid is it's not something that anybody wants to think about. There's a strong component in the population that's prideful, that doesn't want to ever think that they will have to apply for Medicaid, that they're good, upstanding, hardworking Americans, and by golly, they're going to pay their own way and all that stuff. But the fact is, most people in retirement are making $2,000, $3,000, $4,000 a month. And nursing home care is $8,000 or $9,000 a month, easy in Birmingham. That's going to wipe out anybody. I don't care how much money you've been able to accumulate. So it's not a shameful thing to seek Medicaid eligibility.
That's right.
The important thing is to do it well before you need it. If you walk through the nursing homes, any nursing home in this state, I guarantee you, and ask the people there, did you ever think you would end up here? 100% of them will say, nope, I never thought I'd end up here. And nobody wants to go to a nursing home, let's face it. But 50% of every married couple, one of the two is going to go to a nursing home. So let's plan as if it's a reality, not if it's something that we can just close our eyes to and pretend it's not going to happen.
I think that's, I'm not seeing any more questions come across. It's 12:53. Do y'all want to maybe summarize the points from today, and then we'll wrap up our housekeeping and send people on back to their workday?
Well, I had sent to Sean a list of 3 points. One is to help people understand the process, the Medicaid application process, and the requirements, and then to help people avoid, I guess, being taken by surprise. So I wish nobody had told me that, or somebody had told me that before. We want to make sure that never comes up again. And what was the third, Sean? I can't remember the third.
I wrote that they're in the survey, Bill. Let me see if I can pull it up.
Well, there's a lot to this, and And
It's
today,
equip attendees both professionally and personally
yeah,
to be a resource to their loved ones as they face the uncertainties of aging.
yeah, there's a lot online and magazines and things written by elder law attorneys and other people in California, Florida, New York, Texas, the more populous states. The fact is Medicaid is a program administered state by state. So what works in California, New York, Florida may not work in Alabama.
That's right.
Always ask someone locally at how it works here in Alabama, because if you base your decisions on what California law is, I guarantee you're going to be surprised, and not in a good way, when the time comes.
Well, I have one last question, which is selfish and personal, but I have a conservatorship for my mother. I think I've mentioned this to some of the folks on the survey. She won the Publishers Clearinghouse almost. And so I had to establish a conservatorship. Is that protect her in a Medicaid situation, or?
So as a conservator, your job is to conserve the assets of the Medicaid of your party in need protection.
Right.
Your job is to use her assets for her needs, whatever those needs might be. So if she has to go to a nursing home, then it's your job to use her assets to pay for her care until the money's gone.
Okay.
That's how that works. So
So there is no Medicaid planning possible.
well, there's no trust planning possible. You can still set up a family trust or a QIT if you were a conservator, but you wouldn't be able to do any significant trust planning to protect an asset.
Okay. Should I do that now, or does it matter? Should I do the QIT for the income protection, or no?
Now, wait until her Medicaid application is ready to go, and then you could do all that in that month.
Well, by that time, Bill, you will be retired, because my mother is going to live to be 1,000. Yeah, she's going to outlive me, no doubt.
You need to have a successor in place then on your conservatorship, I guess, to you, right?
Right. Yeah. She'll be taking care of me. Well, thank you, Bill. Thank you, Pam. It's been so enlightening today to have you here. I appreciate y'all making time for us and sharing your expertise and many years experience. And of course, Bill will have you back. And I almost really think this is something, if y'all are interested in it, Pam and Bill, maybe we could do quarterly or something, because I think there's enough interest in Medicaid and the application process maybe to sustain us and maybe get another 80 people educated.
Sure, absolutely.
Absolutely. Be glad to.
Great. Well, I've put the Survey Monkey tool in the chat room. Looks like y'all are running away with it, but it's https://www.surveymonkey.com/lowercase r/uppercase B as in boy, G as in girl, T as in Tom, R5. And the CEU code word is planning. And thank you all again so much. We're nearing the end of our hour. I appreciate your attentiveness, your questions, your interaction, and Tamaria, Jerry, offered yourselves as resources to us, which is so thoughtful and helpful, and we appreciate you, and we appreciate what all of you do, not only you, Pam, and you, Bill, but all of you on the phone. Thank you for referring to CarePatrol, for remembering us when you have families in need and crisis who may need a directive hand towards someone like Bill. Please remember CarePatrol. Give me a call, shoot me an email, and y'all keep going back to the website, carepatrol.com, and look for upcoming topics. And thank you again, Bill. Thank you again, Pam. I'm going to shut this down for us today, but thank you, everyone, and y'all have a great rest of your day.
Have a great one. Thank you. Bye-bye.
Thank you. Enjoyed it.
Bye-bye.